Hi friends, I'm Uma Maheshwari. Imagine I wanted to start a restaurant business. So I go to a bank and I ask for a loan and I get the loan also and I start my restaurant business. But due to fate, my business doesn't run properly. So I'm unable to repay the loan, neither its interest. So similarly, my neighbor who started a business also defaults and so many other people default. So if the interest is not paid for interest or principal is not paid for 90 days, it becomes an non-performing asset. And when the level of NPAs rise, so many people who got the loans, we didn't pay the interest. What happens is the banks will be unable to lend to prospective buyers further. So this is the base of twin balance sheet syndrome, and this was the problem which was affecting the Indian economy. So to resolve the NPA crisis and to give a full stop to the twin balance sheet syndrome, the government introduced an important measure which is called the IBC or the Insolvency and Bankruptcy Code. Watch this video if you want to know more about IBC holistically. Now, before you understand the term insolvency and bankruptcy code, you must know what is insolvency and what is bankruptcy. Insolvency is a situation when an individual or a company is unable to repay its financial loan to its lender in due time. That is, if I'm not able to pay the interest or the EMI for a particular period in due time, if I'm not able to pay, I would become an insolvent. And what is bankruptcy? It is the legal status of a person or other entity who cannot repay debts to its creditors. That is, if I cannot pay the interest or principal for this month correctly on time, I become an insolvent. And if I am not able to pay none of the interest or bills, if that is, I cannot hereafter I cannot pay my dues at all, then that status, that legal status, is called bankruptcy. So, and why is it IBC called Insolvency and Bankruptcy Code and not a law or act? Because code is nothing but a compendium of laws. That is, it is a collection of laws, regulations, rules, and all those things are present in the code. And that is why IBC is called a code and not just a law. This is the framework of IBC. See, the Insolvency and Bankruptcy Board of India, IBBI, it is the key regulator. And below the IBBI work the insolvency professional agencies, the insolvency resolution professionals, and the information utilities. And who are the adjudicators? That is, who resolve the problem in case of dispute. It is NCLT, National Company Law Tribunal, and the appellate goes to NCLAT, that is National Company Law Appellate Tribunal. And for the NCLT is for corporate entities such as companies, LLPs, etc. And for individuals, partnership funds, it is Debt Recovery Tribunal and DRAT. And what are the benefits of IBC? Actually, IBC is a single law to deal with bankruptcy. Before the advent of IBC, see, you can get a loan, you can abscond, and there is no a serious law which is time bound to resolve the problem of bankruptcy. So, what IBC did was it repealed most of the obsolete laws and it amended the existing procedures to give an updated code to deal with the problem of insolvency and bankruptcy. And it is a time bound resolution process. That is, now it is amended to 330 days and not 270 days. And this is IBC is where everyone gets their due. You can see the order of priority. So this is the order. Cost of insolvency process will be settled first. Workers, secured creditors will be settled second. And employees, the wages of employees are settled third. So this goes on: secured creditors, government dues, any remaining debts, all these. This is the order of priority in which the dues will be settled. And it covers comprehensively. See, not only companies, partnerships, individuals, but also LLPs. And whoever defaults or whoever becomes an insolvent, this is the only code which can cover entire thing. And there is no deadlock also. You see, when a resolution plan is not accepted within the time period, then liquidation has to happen. So there is no other deadlock. You're going there and here and shifting no red tapeism at all. It is crystal clear. Like this is the plan for revival. If this plan is not accepted, liquidate the company and settle the debts. This is what is a drastic measure with respect to IBC. And there is also a regulator. See, previous cases there will be only adjudicators, but now there is a regulator called Insolvency and Bankruptcy Board of India, and this will keep watch of what is going on in and around IBC, and how are the insolvency resolution professionals and others functioning, all those things. And this IBBA is a 10-member board, and this has both RBI and the government representation. And what is the process of IBC? See, when a debtor the default even for a single day, the financial or operational creditor can apply. It applies not only the financial creditor. Financial creditor is one who gives the financial amount, that is capital. Operational creditor is one who supplies the goods and who gives the credit for that, for repayment of the bills. So they will be the operational creditors. So if the debtor he defaults to pay either the interest or EMI or the bills, then the financial or operational creditor can apply to NCLT for corporate insolvency resolution process, which is CIRP. And then what happens is a committee of creditor is formed, and this comprises of all the financial creditors. See here, the preference is given to the financial creditors, and this was also pronounced in the latest judgment by the Supreme Court, wherein the financial creditors and the operational creditors cannot be treated equally. The financial creditors have preference over the operational creditors because they are secured one. And the COC, they appoint an independent person to function as the resolution professional for the remainder of the CIRP term. And what happens next is the approval of the resolution plan has to happen. So who should approve the resolution plan? The revival plan has to be approved by 66% of the creditors, and that too within the timeline. If within the timeline, if the creditors are not ready to accept the revival plan or the resolution plan, then what happens next is liquidation. So either you resolve or you liquidate, so that the debts cannot carry on after a particular time. This is the process of IBC, and there are some few amendments which are made. I have given only a few important announcements. There are n number of amendments which have taken. Please, before you get into prelims or mains, if there are important amendments, please take a note down of also. So it has now allowed the withdrawal of IBC application. So once a creditor, financial or operational creditor, has applied for IBC, it can be withdrawn only if 90% of the voting members of the COC agrees. So only if 90% agree that no, we are withdrawing from the IBC application, then the application can be withdrawn. And one more important thing is that in the resolution, in the revival plan, the promoters have no place at all. See, if I'm the owner or if I'm the manager of the company, managing the company, so that company has come into the resolution process. So I will not be given any position in the resolution plan at all. But this doesn't hold true for MSME, because MSME, their problems are understandable. So the promoters have some place when the resolution happens. In the resolution plan, they can be a part 2. And home buyers can now be treated as financial creditors. So they can also file an application with IBC. And preference is given to secure lenders over the operational creditors, and thus giving explicit authority over the distribution of proceeds of auction of loan defaulting companies. And as we said, the older timeline was 180 to 270 days, but the newer timeline is 330 days, and it is extendable. So appeals, where do the appeals take place? If the borrower is an individual or partnership firm, he must first apply to DRT, and he or she, and the appeal will go to DR80 of SARFAESI Act, that is Debt Recovery Appellate Tribunal. And if the borrower is a company, NCLT will be the first point of application, and NCLAT, that is National Company Law Appellate Tribunal, that will be the adjudicating appellate authority. And IBC is not applicable to every defaulter. See, there are a few exemptions. Who are they? A borrower who has the capacity to repay, but he is not repaying the loan. That person will not come under IBC because he is a willful defaulter. And a borrower whose loan account is in NPA for more than a year. and he has no capacity at all to repay even partial amount. So this person, this defaulter will not be inside IBC. Why? Because both these there is no need for resolution at all in these two cases, and hence they'll be the assets of these two borrowers will be liquidated directly without a resolution plan under SARFAESI Act. These two will go to SARFAESI Act and not eligible under IBC. There is part 2 to this video. Please do view it to know a holistic view of what is IBC. Please do watch part 2 too. Bye. Thank you.